believe it or not, the law occasionally is logical. And there is a logic to this, where you just have this raw piece of land, and later oil's found on it, but you didn't do anything to develop it or anything. So it's no labor from you or money or resources from the marriage.
So that would be like you're not so lucky in love, but you've definitely lucked out with the things you did before you said I do.
Life's third act. Here's attorney CPA Joe Cordell.
Welcome. This is another episode of Life's Third Act. With this episode, we're going to pick up with part 2 of our discussion of Larry King. Lots of great content here. And if you haven't watched the first one, I encourage you to watch the first one before this one, but you don't have to. I think that your familiarity with Larry King will get you through this second episode. So with that, I hope you enjoy it. In this case, he creates this holographic will, which kind of throws things up in the air. It leaves his wife out. But now remember, we're talking about $2 million, not $155. Leaves his wife out and distributes the money among his children.
Sounds fair.
It does. It's not at all a surprising thing. And that's one thing that often produces challenges to wills, is when something happens that is contrary to what a normal person might have considered. People who are not the natural objects of your bounty is what the law calls it, natural objects of your bounty. So like children, family, et cetera, but instead, you change your will and give it all to a secretary. That in the last days, in a final illness. So those are the things where they always get challenged. In this case, there's nothing weird about it except that it was done at a time when his health was declining. He was not with his wife at that time.
Yeah, he had just filed 2 months after.
Yeah. And so that makes sense too. It makes sense that he had just filed for divorce. So, obviously you wouldn't include your wife in your will. As a matter of fact, most people, one of the first things they do or should do is that they should get their estate planning changed as soon as they get a divorce or even contemplate divorce, at least when they start the process, maybe not necessarily contemplate. But in this case, he decides that he's going to do the thing that a reasonable person under those circumstances would. But he does it in an odd way, and he does it at a time when there are arguments that he's cognitively impaired. One thing about Larry is he was not known as a guy who suffered from Alzheimer's, or there was no evidence of really great decline that many people have, great and small. A lot of people are plagued by that in their final years. There's no evidence that Larry King was plagued by that at all, except that normal sort of decline that you might get when you have physical declines in other ways going on due to, in his case, I think it was it cancer that actually took him?
He had sepsis?
Yeah, an infection. Yeah.
Mm-hmm.
So yeah, he wasn't perfectly clear-headed by any means. And I'm sure the argument could be made that, he wasn't sharp. But the point is, the threshold for having the capacity to change a will is the lowest of anything in the English legal system, in the American legal system. It's the lowest bar possible next to one other thing. What do you think that other thing is?
I'm not sure.
Well, it's marriage.
Okay, marriage, okay.
So you can, in other words, for you to be competent enough to get married, it's the lowest bar possible. And there's a reason for that, is that they think marriage is the nature of it is it's a sacred thing, that human beings, part of being human is to be able to formally have a relationship like that with another human. And so the law took the position that even if you are mentally impaired, not necessarily due to decline of age, but it could be, phrases they used to call imbecile, which became, pejorative word, an epithet. It was at one time a technical term, and so was moron. These were different levels of scores on IQ tests. But you could go very, very low on that test and still be able to marry. So the next lowest bar is to be able to decide who gets your stuff when you die, and that makes sense too. So in this case, Larry, I think he had capacity, but the will was poorly written. It was unclear. There was allegations of undue influence. Where's I find this here?
Yeah, from his son, Larry King Jr., which you have to wonder what their relationship was like and whether
Yeah.
or not Junior liked Dad's last wife.
And can we not suspect that that was not a perfectly harmonious?
I have a feeling, but
So, so yeah, it was Larry King Jr. that stepped forward, and I think he represented all the children, and he was the most prominent in the negotiations because they did file. There was the original will was submitted to the court. Then there was an objection raised and a challenge, and then a holographic will was submitted. And so this would have gone to trial. You had probate expenses in which a substantial amount of money, probably the whole $2 million would have been spent in this. And often that's the case, is it paid for out of the estate of the person who's gone. Not always. If there's frivolous challenges and whatnot, then the court will not allow the fees to be paid. But if it's a good faith claim that arguably is fulfilling the desire and obligation of the person who's deceased, then the theory is that under those circumstances, why should the relative be the one who pays for it? It should be the beneficiary, and really the beneficiary in the truest sense is the person who's died if it was their desire. That means it's got to be a meritable claim, or at least colorable, they call it. So in this case, there was litigation, went on for a while. Thankfully, did not go on long because I think certainly less than a year, and maybe 6 months or so, there was a settlement reached. So remember, this conflict it would have been a real stretch to have challenged the validity of the trust. One advantage that trusts have whenever wills are challenged is that they often are prepared early enough in life to where there's not arguments of last moments, of dementia. There are fewer arguments about undue influence simply because the way you effectuate a trust is that over a period of time, and that period of time could be just weeks, but over a period of time, you're actively transferring assets to it. Requires your participation, not in signing a document simply like a will, but it requires your participation in a whole series of events. And in fact, if you live for another several years, as Larry did here, then it requires your participation in an operation, meaning operation like a business. So that's simply to say a trust is an entity that you have to operate correctly, that you have to do the things you have to do over time. So the probability that a trust would be the product of something where there was manipulation is much less likely where it's shown that there was such participation over a period of time by the deceased.
And how often should someone update their trust?
Usually after major life events. In this case, it was interesting that there was no update to the estate planning, to Larry's will after the death of the two children in 2020. In other words, if he was operating under the assumption that he was going to give his money now to his children, and that was what the holographic will said, which he created in 2019, then you'd think that the event in 2020, the death of two children, would call him back to the table to make some changes. Now, it's possible that he could have anticipated children who predeceased him. That's not at all unusual, and there would be provisions in there for it to go to their direct heirs. So it could be that a person in Larry's position would rationally say, I don't need to make a change, though these two children have died. But often when you have something like that among primary heirs, usually you do want to go back and look at things that you found out since then, maybe about their family members, maybe about their children, lots of things. So he didn't go back and make any changes. So that was an argument against his clarity in creating the holographic will. In this case, though, I was glad that it settled. And I suspect that it would be perfectly rational for Sean to not make too big a deal over that and not allow a challenge to the trust to have been made. I think that even though, for the reasons I said, that a challenge to the trust would fail, it still was going to just produce a lot of conflict and a lot of money. that would be wasted. So this matter was settled in short order. So this is not a case where you have a celebrity who's the conflict between the stepmother and the children it consumes the better part of the estate, or it certainly consumes the better part of a decade in these cases we've looked at. This is a popular theme with us, Sherry, that we actually go back and we talk about, specifically look at situations involving celebrities in which there's a stepmother. It does sound a little sexist. It's not deliberately sexist. It's just that we didn't see as much where it's the father that is going to war, the stepfather that's going to war with the kids of his deceased wife. There's not as much of that, but there's a lot.
There's more moms. Yeah. Well, there's
Yeah.
more movies that are created with the stepmom, the wicked stepmother.
Yeah, you
So,
wonder where did that come from, that stereotype?
there's reason for it, I guess.
Yeah, stereotypes often have reasons. So anyway, one thing I wanted to talk about, though, that I think is something worth thinking about, and I think was probably considered by Larry's lawyers. But whenever you have a pending divorce, it really produces more complexity because you have to decide what assets belong to the other party that would otherwise have been distributed to them in a court case that's currently pending, and then be sure to likely just distribute the other assets. Now, the court doesn't have to do that, but many probate courts are affected by something pending in a divorce court, and especially in a state where there's community property laws. So community property laws presume that whatever was acquired during the course of the marriage is going to be a marital estate. So it's going to be half owned by wife, half owned by husband. So I mentioned a while ago, the implications of having a long marriage is that half of what you produce typically, and particularly in a community property state, as opposed to the alternative is an equitable distribution state. And that's more common in America. But you have some, I haven't kept track of the count, it's changed. You probably have now 12 community property states, right? That's not an exact number, but roughly. So I think that in this case, there were assets that clearly had been accumulated with the marriage this long. So whatever contracts Larry signed, whatever business ventures he entered into, anything that related to an asset acquired after the date of their marriage, did you say it was 98?
It was, let me double check on that when they got married, because it lasted 22 years and they got married in 1997.
So from that time on, those assets would be presumably community property. So that means that technically the only thing that's being distributed by this trust, unless his wife participated in 2015, then would be the assets that he would be deemed to own, because that's all he'd be capable of distributing in a community property state for assets that were community property. I suspect that husband and wife both participated in that. I'm guessing that there's probably almost a mirrored trust in which she does similar planning. Their planning probably had some tax considerations involved because of the magnitude of the estate. So that would affect how they can draft these. They can't be perfect mirrors if they're wanting to get full tax benefits. But the point is, I think that she participated in the estate planning. My guess is she had a trust, a similar trust, in that was something that the parties expected to be the way things were ultimately resolved. And I'm sure they were ultimately resolved that way with his death. And that's the reason they didn't pursue the divorce. But absent that, if the conflict had still gone on and he had wanted to convey less to her than the community estate, then her divorce process would triumph in that. But the laws are very similar anyway. So she would have a claim to take against any will to begin with. And as to assets that went into the trust, let's assume the worst. Let's assume that he had accumulated these assets, much of them during the marriage, and let's assume that they were $100 million, for example. And he took the position, look, I earned this money, it's mine, these assets I've accumulated, so this $100 million I'm going to put in a trust, and I'm going to call it my trust, and I want to distribute it to whoever I want. That obviously be a violation of community property laws in California. And that would be, and if it wasn't discovered till his death, which is possible that could happen, meaning he could in the background, and this has happened. I've seen it, not with our clients, thankfully, but I've seen where people will go behind and change titles on things and their spouse doesn't know it. And somehow they get by with changing the title, like with a recorder of deed. And normally they would need their wife to sign to transfer it to themselves individually. But however it's done, often or sometimes you'll find that the surviving spouse discovers only after the death of his or her spouse that assets have been transferred into this trust, maybe even 5 or 10 years before. And they had no reason to know that. They weren't monitoring such things. It didn't come up. In those cases, it's considered a fraud on the marital estate because it's like you defrauded your spouse, which you did in that case, according to California law. You would have defrauded your spouse, and she would have a claim to recover that out of the probate court. So again, my belief here is that they jointly did this. It's suggested by the fact that she's a trustee of the trust. So I think there's probably a trust in which she created that's a counterpart to this. So whenever you have a divorce pending, though, people need to be aware what the implications are for what you can do and what you can't do. Another thing that came up with this case is I was wondering, did he do a prenup? I didn't hear anything about a prenup.
Yeah,
Did
I
you?
was wondering about that too. There was I thought I saw somewhere there was a post-nump.
Well,
And I'd
was
never
there?
heard
I
of
didn't
that.
read that.
I had
No,
never
you
heard
could
yet.
do-
2 post-nuptial agreements in his estate
Oh.
planning documents. So I was like, I had never heard people doing those. I had only heard of prenups, but not postnups.
Now that's interesting. I'm glad you told me that. I didn't know that because I didn't see it. And what I was researching, my resources didn't know that. So this was done. There were 2 post-nup agreements.
Yes.
That's interesting. So, look, comment on that. Post-nup agreements you have to be more scrupulous, conscientious when you do those because they're always subject to being overturned potentially by a court. Remember, you're taking rights that already exist and you're having one party, well, both parties would waive what the law would otherwise be in exchange for doing something different. When it's a prenup, it's a little different. I mean, at the time that the prenup is signed, they're not husband and wife. The wife, you still want to be sure she has a lawyer. You still want to be sure that that the I's are dotted and the T's are crossed. You want to do all those things, with great care to assure that it will survive a challenge later. But postnups are more vulnerable to being overturned, and sometimes people will even want to get a declaratory order by a judge to assure that an agreement they've reached is okay. Because you can imagine what would happen. You can imagine that there was a time when there was often great differences in sophistication between the husband and wife. So you have a husband who, I'm stereotyping here, but you have a husband who is much more knowledgeable, maybe a little more dominant, and you have a wife who is not as knowledgeable about the business affairs. And so he'd be in a position to get her to sign a document which she waived everything. So you can see that the opportunity
Sneaky.
for abuse. So postnuptial agreements, yes, you can do them where people reallocate their rights after marriage, or during the marriage, I should say. But
Would that be something that he could buy them out of, let's say, future monies that could be involved with any type of trademarks, or let's face it, all of his former shows, all these interviews he's had with such influential people throughout history, that if, let's say, a movie is going to come out and it's going to feature, say, even Donald Trump before he became president, he interviewed him several times. So say that's going to be in a documentary, they're going to pay for the likeness of Larry King to be able to share that. Where does that kind of money go? Because I would imagine that would probably be part of a trust, but where does that come from?
Yeah, well, let me first say any intellectual property would certainly be the subject matter for the trust. But in this case, while definitely there's intellectual property with Larry King, his brand, his name, his voice. But I think that those recordings, depending on what the deal was, typically when you have someone working as an employee for you, like at CNN, you give up any claim to payment relating to those recordings in the future. So you don't own the reproduction rights, et cetera, associated with those creative things. Now it's possible though at the radio show there could be some of that. I don't know how, but most that would be very forward thinking. My guess is that he doesn't own that, but he could have. But one thing is clear. He did own things relating to projects bearing his name. You suggested maybe a show or a movie. Those things he would be paid for, or his
Yeah, he was in
estate.
Ghostbusters.
There you go. So
And
he
his voice, yeah.
maybe he gets some residuals on that.
And Sesame Street. I mean, he did the big stuff. You know,
Well,
I mean, he voiced several different characters, and I mean, there's a lots of things that could be, seen again. And I would imagine there's some money there.
Yeah, certainly. And so those are things though that interestingly, she would own half of those absent this agreement. Yeah, any of those things that occurred during the course of the marriage, she would own half of. And we talked about this a lot with Glenn Campbell, and how with Glenn Campbell, his most successful years were to it was his first wife, I think, but his most successful years were the period from 69 to, I don't know, 77, 78. So there's a period of time there that captured virtually all of his great hits. I think there was one that wasn't among those. But other than that, I mean, that was where the money was. And so that wife, appropriately, she got a substantial amount of his assets when they divorced in late 70s. And it turned into a lot of money thereafter for the family. So in this case, though, I don't think there was certainly not a prenup. And now that you tell me there was a couple of documents signed later, post-nups, then that also could affect their rights. And I'm going to assume they did that correctly. They had lawyers, each was represented. The bargain was not incredibly one-sided. That would look very suspicious if viewed later in a challenge. But where the deal has a certain merit for both sides, where it makes sense, then the court is likely to uphold it. But just keep in mind, post-nups are, as a rule, more vulnerable than prenups. I would say that in terms of assets before the marriage, let me make one clarification. Any asset that you owned before the marriage can still, in terms of appreciation, be picked up. So I'm sure Larry had some of those. So it's ironic that your spouse will have a claim to the assets that existed before the marriage if you added substantial value after the marriage to those assets by way of your efforts or other resources of the marriage. It could be money of the marriage that you invested, like we'll say an apartment building. You owned an apartment building before you got married. And after you were married, you decide, gee, I'm going to renovate it. I'm going to do all these things to make it nice. And you pour, tons of money into it. It's worth twice as much, 3 times as much. And then you later say, look, this is a separate asset. Well, what the court will say is that whatever value you added thereafter is going to be community property. So those things, the community estate is entitled to be repaid. So it means that it's divided 50-50. So that your wife, in this case, wouldn't get all of it. She'd get 50% of it, which is a big chunk if the asset appreciated a lot. And here's the irony. If you have assets that appreciate without your efforts, remember, whenever you're married, your spouse owns your labor. If you have a job and you're an executive and you're making $1 million, $10 million a year, whatever it is, your wife owns half of your income. I mean, your labor is a marital asset. So that means that if you own an asset where, again, through resources of the marriage or your own efforts, you increase in value a lot, that's what the marital estate will have a claim to. But what if it just goes up in value? What if it's like gold sitting in a vault and it just goes up in value? Well, in that case, interestingly, there would be no claim by the marital estate because marital resources were not used. There's a logic that, believe it or not, the law occasionally is logical. And there's a logic to this where you just have this raw piece of land, and later oil's found on it, but you didn't do anything to develop it or anything. So it's no labor from you or money or resources from the marriage.
So that would be like you're not so lucky in love, but you've definitely lucked out with the things you did before you said I do.
Yeah. And matter of fact, there is a case There was a billionaire in Texas who was getting a divorce. He wasn't the client of Cordell and Cordell, but he was getting a divorce. And I remember reading about this case in which he was in the odd position of saying that what he did was he bought these leases on land in which they knew oil was there, but they didn't think there's any way to recover it. This was before fracking technology and all that came along. So these were wells that had been abandoned essentially by the major oil companies. So they were being sold in large quantities. And he went in thinking, who knows, there may be a way someday to get this oil. But remember, the best technologists at the time said there was no way. So one could argue it was a foolish decision. So he buys all these leases for hundreds of thousands, probably millions of acres. And this is up in that area, that basin area. I think it's North Dakota, that area that extracts so much oil. And then, of course, later we know the story. They figure out a way to get it out. So this guy becomes hugely successful. And here's the interesting argument during the divorce. His argument to the court is that, yes, I had done some things in this asset that I had owned before the marriage, which he did. He bought these before his marriage, and then he's married for another, say, 10 years after that, and he's getting a divorce. And his argument to the court was that, I didn't do anything for this. I couldn't possibly. I'm too incompetent regarding business. I don't know how to make good decisions. I stumbled into this. This became worth billions of dollars by no efforts of mine because I'm not smart enough to be of any value in increasing this asset. So it was a weird argument. The court didn't buy it, but the argument was that there was no contribution by him, even though there were things that were done. And because it wasn't as if it were just simply he owned it and someone called him one day and said, let me give you a bunch of money for this. He owned it. And then he did some exploratory things. And so, as you might expect, with the story like that, there were some things he did. He didn't do a lot, but he did some things. And so the court concluded that this $1 billion plus assets, there's a couple billion, the marital estate had some claim to it. They weren't giving the marital estate all of the increase in value, but they acknowledged some. So that's a little bit of a rabbit trail. But I like to take these shows and see it as an opportunity to talk around our specific subject as well as specifically on it. In this case, Larry King probably had some assets fitting the description of his doing nothing. I bet surely he owned some real estate that he didn't do anything on.
Yeah.
I mean, so we can imagine, and even intellectual property that, like you mentioned, there probably is some intellectual property of various sorts that predated the marriage and that he didn't do anything to enhance the value of during the marriage. So those things will be his separately, and there was no community property claim to that. But the other assets, and I suspect clearly most after 22 years, would be marital assets. So how do we wrap this up? Are there lessons here? What occurs to you, Sherry?
The lessons, just be really smart about who you're going to marry. And try to keep the number low, I would think. Less headache. But, I hear people talk about it all the time about like winning the lottery. Well, if I won the lottery, I'd leave my husband or this or that. And I think you make a great point that if you win that lottery, when you're married, they get half of it, whether you're the man or the woman, right?
And so if you win the lottery, your spouse may be happy for you to divorce them.
There you go. Might be a win-win in so many directions.
So, I do think that the thing with the marriage is it's just hard to defend that. It just seems like such poor life planning in some ways, and you're reluctant to be critical of a great person who's obviously, Larry King has special talents. Nobody could do what he's done. But it doesn't mean that the decisions he makes in the rest of his life are equally as good. And in this case, I just shake my head as I looked at how he lived his life in terms of his marriages and even his children. again, we won't dwell on it, but there wasn't much evidence that he was very committed to his children's lives. He did bring back into his life one or two of his children later on, and I've read places that he maintained some contact, certainly, and I'm sure he did maintain some contact, but there just wasn't the assumption of the role of a dad that you think there should have
Yeah,
been.
well, him losing his father himself at 9 years old, he probably didn't really have that, that father figure in his life to kind of guide him to where when it was his turn to become a father, that he would, know a little bit better about how to go about it. He was
Yeah,
just probably a workaholic,
yeah,
I would imagine.
yeah, I think you're right. He had to have been working those hours. Uh, So apparently, also we should mention in terms of differences with Sean that led to the divorce. I didn't know this. She was Mormon, and he was I don't know that he was an atheist. He was agnostic. So even though he was Jewish, apparently, he wasn't religious. So that was an area of conflict that hovered for some time. And then I think that these arguments of infidelity, I mean, that poisons any relationship. If you have spouses thinking correctly or incorrectly that the other is having an affair, I mean, it's going to really damage the
Yeah, that
relationship.
seed of doubt. That's all it takes. And then you can just spiral out of control.
Yeah, yeah. But Larry, he left a legacy where his name will be remembered for a long time. He truly had a gift for doing interviews, and it was so welcome. Just a comment of his successor. His successor was Pierce Morgan. Do you know Pierce Morgan?
Yes.
Yeah,
He really
uh,
stirs the pot.
he does. He does, and he's kind of changed a little bit in the last few years. He's more conservative, it seems, than perhaps he was before. But I think CNN, of course, they saw that Larry King was aging, and so he's going to have to move on sooner or later. But also, there had been success on Fox in the evening, like Hannity. There had been some debate shows, and there was also another debate show on MSNBC. So I think that CNN felt that that was where, public tastes were going. And so they replaced Larry King in the style that we just described, the very friendly, warm style, with its antithesis, which is a very confrontational show, Pierce Morgan. So Pierce Morgan went on immediately after King's show concluded, same time slot, and he lasted, I think, just at 2 years. And it just wasn't working. His ratings went up initially because it was something different. People liked it, but it had no enduring value. I mean, imagine a show. There's been no other show that's lasted this long on CNN, 25 years. I mean, so it was something special. He struck into something that was enduring as opposed to just a transient fad. And I think Pierce Morgan, who I do kind of like, I think Pierce Morgan is sharp. And I especially like his views probably a little more now than I did at one time. But the public, they enjoyed being able to hear people speak to each other in a friendly way and to have a conversation about their lives, their background. And Larry was so self-effacing. He never wanted to talk about himself. And
This
many
is like Johnny Carson, like we talked about earlier. I mean, there
good
are so many,
example.
so many similarities in the two. They're just kindness, really, just wanting to get to know whoever they were interviewing.
That's a very good point. Carson famously didn't want to talk about himself. So, those are qualities that for some reason are hard to find in interviewers. But this was a great topic. So I don't know we don't know exactly what we're lining up next.
It'll be
But
something controversial.
yes, well,
Or will we be nice, like Leary would be?
yeah, I don't think people mind. I mean, you and I have good conversations, so we can talk about controversial subjects. Well, with this, Sherry, I think we'll wrap this one up. Soon, you and I will be doing a new celebrity, new issues, doubtlessly some common themes. So this has been another episode of Life's Third Act. Till next time, take care.
You've been listening to Life's Third Act. Each week, we discuss topics and answer questions to help you better plan for your future. Subscribe and listen again next week for another edition of Life's Third Act, The choice of a lawyer is an important decision and should not be based solely on advertisements.